Okay. Again, welcome to our webinar, Coronavirus and Michigan Community Associations Best Practices. Mr. Robert Meisner will be our presenter today. Mr. Meisner is the principal attorney and founder of the Meisner Law Group. And we are based in Bingham Farms, Michigan, where we have provided legal representation statewide for condominiums, homeowners associations, individual co-owners, and developers for over 40 years. Mr. Meisner was the first lawyer in Michigan and among the select few attorneys in the country who have been recognized with fellowship in the Community Associations Institute's College of Community Association Lawyers. His book, which I can show you right here, Condo Living 2, the authoritative guide to buying, owning, and selling a condominium, is available at momentumbooks.com. And he has also formerly served as an adjunct professor for college courses on community association law. My name is Mark Petrie. I'm a legal assistant and director of community relations at the firm. I'll be helping out today. At this point, we'll turn it over to Mr. Meisner and get started with the first slide in our presentation.
Okay, thanks very much, Mark. For those of you who are looking for a beach, I just heard that Marco Island here in Florida is now open. So as crazy as that sounds, you know, if you want to go to a beach and you're crazy enough to do that, Marco Island is open. Thanks for joining us today, and we're going to try to deal with some issues that are prevalent in community associations now and in the future. The virus, as I'm going to refer to it, has obviously caused us to dramatically reevaluate how we live our lives and how our relationships are with one another, which of course impacts on community associations and how they function. So we must not only address the current rapid rise of cases in Michigan, but also be prepared for the future when similar pandemics may occur. And by the way, let me just put in this disclaimer, hopefully as a good lawyer, that any advice I give you is not to be relied on as it relates to your own association, because every community association has hopefully its own set of documents, its own master deed or declaration. It has its own sets of bylaws, so that while we're talking in general terms, this is not a substitute for individual legal advice that you may want to seek from your hopefully competent community association attorney. And we have, I noted several community association attorneys listening in today. So if I say something crazily or wrong or whatever, you know, just write us a note and we'll take a look at it. But try to be kind about it. You know, I sound like Trump, right? Only nice questions. In any event, let's initially look at the Governor's Executive Order 2020-21. All public and private gatherings of any number of people occurring among persons not a part of a single household are prohibited. So obviously this includes board meetings and association membership meetings. And so what we have to do as board members, as practitioners in community association law, is to explore the options for meeting via video conference or teleconference. And obviously there are some programs that are set up for that. GoToMeeting, Zoom, which I suggest you use with caution given some of the privacy issues that have circulated because of that. Google Hangouts. So obviously how and when to hold your membership meetings needs to be addressed with your legal counsel, because obviously many of you have meetings set up for April or May. You may have had meetings set up for the third Tuesday in March, which so many documents over the years provided for, and you probably didn't have those meetings. So these are issues that you're going to have to come up with in terms of dealing with your own association. Now, I guess the first question is, how do we deal with some of the issues regarding meetings, and what are some of the solutions? You know, can we hold membership meetings exclusively by remote means? Yes, you can, unless it's prohibited by your articles of incorporation. Those are the documents that are filed with the state of Michigan when the corporation is established. They may have been and should have been amended over the years to deal with changes to the Nonprofit Corporation Act. But obviously, unless they're prohibited by the articles or your bylaws, according to the Michigan Nonprofit Corporation Act, you can hold meetings exclusively by remote means. Now, obviously, just like any other meeting of the association, you have to have a list of the members entitled to vote at any regular meeting available for inspection. And again, in the context of a remote meeting, that has to be available electronically. In other words, it has to be accessible electronically. And obviously, you must give notice to the membership to be able to provide access and obtain information from those meetings. Now, that doesn't preclude you from using proxies. So in a situation like this, although, believe it or not, there are some association documents that prohibit proxies, that in the context of this type of situation under which we're operating may be very helpful. Section 4053 of the Nonprofit Corporation Act says, unless otherwise restricted by any of the provisions of the Articles of Incorporation or Bylaws, the Board of Directors may hold a meeting of shareholders or members that is conducted solely by the means of remote communication. So if you're having problems in terms of figuring out how you set that up, not only technically but legally, that's something that you want to discuss with your legal counsel. Can we hold board meetings exclusively by remote means? More than likely yes, I should say, unless prohibited by the articles or the bylaws. Again, 521.3 of the Nonprofit Corporation Act. Obviously, you want to create a record of any official location for the board meeting, even though they're participating remotely. So the board meeting took place somewhere in the world. And just to be on the safe side in this type of situation, when things hopefully come back to some degree of normalcy, at the next board meeting that you have, ratify all the prior acts that you've incurred or undertaken remotely. So that's something as well to keep in mind. Can we elect directors by an action without a meeting? Again, you can do so if authorized by the articles or bylaws. Now, admittedly, most documents that I've seen over the years are drafted for community associations and or developers have limited the ability to elect directors unless there's actually a meeting. But assuming that there isn't a prohibition on that, or I should say, unless it's authorized, you can elect directors. Can you elect directors by action without a meeting? Only if authorized by the articles. That's what I'm trying to say. Section 4081 says a corporation may provide in its articles or its bylaws that are approved by the shareholders or members that any action by the shareholders or members are required or permitted to take at an annual or special meeting, including the election of directors, may be taken without a meeting if the corporation provides a ballot to each shareholder or member that is entitled to vote on the action in the manner provided in Section 404 for providing notice of meetings of shareholders or members. A provision in the articles or bylaws authorizing shareholder or member action by ballot shall not preclude calling or holding an annual or special meeting of shareholders or members. So even if you do certain things by action without a meeting, that doesn't mean that you don't need to have or should not necessarily preclude the holding of any other type of annual or special meeting. Okay, so you do have flexibility both in terms of calling board meetings, conducting business as a board, conducting business as an association if that's what you choose to do, and your documents are in order in that respect, and or you've gotten a legal opinion that authorizes you to do it. Why do you need a legal opinion? Because we lawyers need to make a living. And that's one of the most important reasons, okay? But also because if the meeting is ever questioned and there's an issue about the propriety of the meeting or the business decision that the board made in order to conduct that meeting, if you have a written legal opinion from the attorney, then you're off the hook pretty much because you relied to your detriment, as it were, on the advice of counsel. Okay, let's look at the governor's executive orders, which I don't need to go into in great detail, but obviously we need to repeat it for those who have been hibernating for the last 2 months. No person or entity shall operate a business or conduct operations that require workers to leave their homes or places of residence, except to the extent that those workers are necessary to sustain or protect life or conduct minimum basic operations. This, in our judgment, includes association operations. The minimum basic operations likely include many of the management company's duties, although management companies are cutting back in terms of cutting the grass and things of that sort. On the other hand, they are taking care of emergency services, a flooded basement, things of that sort. But again, that is in the eyes of the beholder, so to speak, in terms of what each management company wants to do. A minimum basic operation likely doesn't include landscaping services. Again, businesses and operations must determine which of their workers are necessary to conduct minimum basic operations and inform such workers of that designation. How that impacts on a community association is obvious. What do you need in a high-rise building to maintain its operations? What you need in a high-rise condo or apartment is different from a site condo where everyone has their own home and they're responsible for it, and hopefully they're hunkered down in it during this emergency. So, what is a essential service and what services need to be provided by the association and or the manager or the managing agent will obviously be dependent on the nature of the physical structure that we're talking about. Then, of course, there is a Governor's Executive Order 2020-19, quote, no person shall remove or exclude from leased residential premises or residential premises held under a forfeited executory contract, a tenant, a vendee of a forfeited executory contract, or a person holding under a tenant or vendee, except when the tenant, vendee, or person holding under them poses a substantial risk to another person or an imminent or severe risk to the property. In other words, you can't kick anybody out during this time unless they pose a threat or risk to the property. So, for example, a hoarder, and obviously we continue to have them in our community associations at sporadic times, and we've been successful in getting injunctive orders and getting the hoarder to be required or have a separate agency come in and take care of the problem. But if you have a hoarder who's continuing to create a safety or health issue, that's something that you can deal with. By the way, the governing documents of the association could be considered executory contracts. In other words, both parties have an obligation to comply with the terms of it. So while you're not able to kick anyone out, and that of course precludes the association from seeking to evict a tenant for not turning over to the association the rental payment. There may be situations where the tenant is a threat to the security, safety, or whatever of the community association. The Federal CARES Act, I'm not going to spend a lot of time getting into that, but we do have a handout that the Community Associations Institute provided to us. There's also the Paycheck Protection Program loan, again, a handout we're giving you. The foreclosure moratorium on federally backed mortgages, in our judgment, it doesn't prohibit community associations foreclosing on their liens. and if you have employees of your association or your business review the new family and medical leave provisions under the Act. They may be talking about suspending consumer debt collections. It's not entirely clear whether community associations will be approved for SBA loans. I've seen comments on both sides of the fence, and we'll go from there. The Step Forward program. Well, one of my dear competitors, former associate, has been sending out notices to people saying, "Hey, look, this Step Forward program is your savior, and we can do so for a flat fee." Look, the Step Forward program is nothing new. It's been around since 2008. It is a application form that the association has to fill out. While I am always the first to suggest that you get legal counsel to deal with contracts, in my judgment, it doesn't require a lawyer to necessarily fill out the application, assuming that there's money available. We're also told that the application includes a required agreement and a board resolution. But the main drawback seems to be it takes a long time to get paid. We've heard 9 months. It's a greater administrative burden on that association. You're going to have to share information and documentation with the Michigan. I knew that was going to happen. Sorry about that. Must be a client calling already. I'm sorry. I'm not going to take it. In any event,
that's my fault. I forgot to remind you to silence your cell phone.
Yeah. Well, that's a major task on my part, to figure out how to do that. But I'm working on it. I just did it. Okay, so getting back to the Step Forward Michigan, it requires the association to share information and documentation with the Michigan Homeowners Assistant Nonprofit Housing Corporation. So there is some modicum of a loss of privacy. There are no penalties in the contract for breach other than termination, and the requirements to satisfy getting a loan are that, if I recall correctly, that you've got to have less than $10,000 in reserves in your bank account in order to possibly get relief. And it's something that the association should consider. Whether or not they need a lawyer to do it or whether they want a lawyer to look at it is certainly up to them. But I think your legal fees could be expended in a much more productive manner than that at this point in time. But again, that's something that's available, and we'll be happy to help anybody, as would a number of other lawyers, if you want some assistance in that regard. Now, here's an interesting issue that, frankly, I don't know the answer to, and I'm happy to entertain any recommendations or suggestions from any of the lawyers out there, or anybody else for that matter. Under MCL 450.2261, it states as follows: a corporation, subject to any limitation provided in this act, in any other statute of this state, or in its articles of incorporation, has the power in furtherance of its corporate purposes to do any of the following. And under sub D, it says, adopt, amend, and repeal bylaws, including emergency bylaws relating to the purposes of the corporation, the conduct of its affairs, its rights and powers, and the rights and powers of its shareholders, members, directors, or officers. Now, what is not clear from that, in my judgment, is who has the right to evoke these emergency bylaws, or to amend, adopt, or repeal bylaws. Is it the co-owners, which they always have the right to do with 2/3 approval, or is it the board of directors? And if so, what kinds of changes can they adopt or amend to satisfy this section of the Act? I mean, I could see this section being a arena for great abuse on the part of an association. On the other hand, it was obviously designed for this kind of situation. In other words, if this isn't an emergency, there never has been. In all my years, I've never seen anything like this, although we have been involved in dealing with issues in community association governance, management companies going out of business overnight, the 2008 financial disaster, and other problems that have arisen in my experience of 45 or so years in doing condo and community association law. But I honestly don't know what kind of emergency bylaws could be adopted and by whom. And so that is an interesting and, in my judgment, open question. On the face of it, it says the association. Now, does that mean the co-owners or does that mean the board of directors? But that's a tool in the toolbox, and that's why we're doing this seminar, to advise you of these kinds of tools that are available depending upon the circumstances of your particular development. Okay, some literally housekeeping issues. Obviously, if you haven't already, you want to close non-essential amenities like pools, gyms, clubhouses. You don't want to be in a situation where you are going to be held accountable for being irresponsible with respect to how you've maintained your condo development. For example, in the condo down here in Naples, I happen to be on the board of directors, believe it or not. We closed the pool. We closed the barbecue grill. We didn't want to be in a situation where we were in a position to be held accountable for the transmission of the virus or encouraging the transmission of the virus. In other situations, the laundry room. Maybe you need to limit access to certain units at certain times on a rotating basis to go to the laundry room. What about the elevator? What if you have an elevator in your building? You want to limit use to one family at a time? Is that the rule? Are you going to prohibit guests and contractors unless allowed as an exception to the governmental order? In the condo that I'm in, somebody's downstairs getting a workman working on their unit right now. Of course, Florida has been somewhat lax in terms of how they've enforced this whole virus situation, but apparently people can still do their work here. Realtors, apparently in Michigan, as I understand it, they are not considered critical infrastructure workers under Rule 220-21 of the governor. In Florida, they are. They're considered essential workers to market the units. So a lot of it is unfortunately political, depending upon the political sentiment of the governor or the local representative. But again, to a certain extent, the association has arguably a responsibility to monitor these things. And if realtors are coming into your condo and trying to have open houses, I think you need to do something about it, particularly if it's specifically in violation of a governmental governor's proclamation. If you're in an apartment complex or a high-rise, you need to make arrangements to clean more frequently, and you need to focus on high contact areas such as doorknobs, buttons, levers, handrails, things of that sort that are common areas where no one particular co-owner is responsible to maintain those areas. And you're going to want to install sanitary stations and common elements. These are all common sense items, and hopefully and presumably all of you have done this in your particular situations, but it's worth repeating, because to the extent that you don't think you have a responsibility for the common areas to do any of this, and you're leaving it to the co-owners, which they should be doing as well, of course, it's ultimately your responsibility. And when the dust settles and there are issues about how careful the association was in conducting business, I hate to see what kind of potential lawsuits there are going to be, whether they're legitimate or otherwise, in terms of how the community associations functioned in protecting its residents. You know, the general rule with respect to the association being held accountable for criminal activity was the criminal activity foreseeable? That's the real question. Foreseeability is the issue that the courts look to. And if, in fact, it is foreseeable that nobody's cleaning the hardware on the door to the apartment building and nobody's cleaning the elevators and people end up dying, I don't know what the consequences are going to be, but a good personal injury lawyer will probably figure out a way to deal with that. Close, clean, connect. Connect with your members and ensure that you have an efficient member of distributing information. Keep them advised of what you're doing. You haven't fallen asleep at the wheel. Use your management company if possible to disseminate information about what's going on. You may try video conferencing for informational meetings or even an online event like an exercise or yoga class. Yeah, don't do it in person. Keep in touch, ideally keeping faces and voices in front of one another. It helps keep morale high and ensures that supporting the community through payment of assessments will remain a financial priority, which we'll get into in a second or so. Assessment collection. Okay. We've already been approached by obviously a number of our community association clients in terms of how to deal with collections. Our philosophy has always been to be reasonably aggressive in collecting assessments, irrespective of the excuse. Not that we are hard-headed, but the association's lifeblood is the collection of assessments. And some people obviously abuse their prerogatives in terms of not paying assessments even under the best of times. So some associations may wish to consider adopting a temporary policy allowing those recently suffering job loss or other financial losses or issues to apply for a moratorium on collections. My personal view is that the collection policy should not be undermined by the board of directors at this point in time. Each association is going to have to make their own determination as to what, if any, concessions they're going to make. The question is, when are the concessions going to be made? I would not necessarily subscribe to the idea that you write a letter to all your members saying, hey, look, if you got a problem paying your assessment, let us know and we won't bother you. No, that's not something that I would recommend to the associations. I would say to them, wait to see what happens. Not every association is going to be impacted the same way as another. And not every co-owner is going to be impacted the same way as another co-owner. Some co-owners are going to take advantage of the situation. Generally speaking, our view is keep the association's collection policy in place. However, be prepared to deal on a case-by-case basis with various delinquencies and determine on a case-by-case basis, depending upon what you require for proof of inability to pay, etc., what the situation is. The Community Associations Institute on a national level has recommended, hey, give them a break, let them know you're doing that, be sympathetic and understanding. I don't necessarily agree with that, and I don't necessarily agree with a lot of things that the Community Association Institute does in certain respects. But be it as it may, it has to be individualized to your particular situation. You have chronic delinquents that have never paid their assessments on time. They need to be considered and treated perhaps differently than somebody that has always been current but all of a sudden has lost their job. They can document that, et cetera, et cetera. So in any event, whatever you decide to do, just don't do it off the seat of your pants, so to speak. Consult with legal counsel because in the last analysis, you do not want to undermine your collection policy. And this hopefully will pass at some point in time, and you want to be left in the most secure financial condition that you can be. And frankly, the assessment should be a priority. It's sort of like your mortgage or anything else, You've got to keep the association functioning, and so keep that in mind in terms of the policy that you adopt. Okay, another difficult issue to think about here. What about a positive test of a homeowner? I can give you an example of what transpired here in Naples, and I'm hunkered down here for a while. I'm not leaving until the dust settles. So our office is fortunately mobilized to deal remotely with all of the issues, and we're able to function reasonably well. And so I'm down here in Naples, and obviously you can tell we're still doing programs and starting lawsuits and all that kind of stuff. We're not going very far with starting lawsuits, obviously, but we're trying to function, and we're doing condo docs and things of that sort, which you can do without necessarily having to be in the office. Somebody did test positive down here, and the association notified us of the fact that somebody did test positive. They are no longer on the site. They did not give their name, but at least down here they felt the responsibility of letting the co-owners know that there was a problem down here. Now, if the person with the virus authorizes full disclosure in writing, then the board can disclose the person's name to the membership. This allows the residents who recently had contact with the person to take additional recommended actions, such as getting tested for the virus. So obviously, if you're in close quarters, if you're in a high-rise or an apartment building or something like that, that is much more of a profound problem than, if you're in a site condo where you haven't left your house and you don't interact with your neighbors in any particular fashion. Particularly vendors who have had contact with the person may also be alerted with written authorization from the person, but the board should not otherwise provide the information outside of the community. So I think the board has an issue here, just like if a sex predator was in your community, what are the responsibilities of the board to disclose that there is a sex predator living in your community? This is a little more invasive in terms of the responsibility on the board because of the life and death nature of what we're talking about. Now, if the infected person does not want to disclose their status, the board may still have a duty to notify the membership that a confirmed case exists without disclosing the person's name or other identifying information. However, the disclosure should be limited to the residents so that they can take, if necessary, extra precautions to protect themselves. Again, you may want to consult, or you should consult with legal counsel before taking any action, but do not attempt to prohibit the person from traveling to and from their residence. So the whole issue of disclosure and what do you do if someone contacts or contracts the disease and how you react to it is, again, something that the board of directors is going to be confronted with. Hopefully the board will find out about it. I don't know if there is an obligation on the part of the public agencies to disclose to the particular environment involved whether or not someone contracted the disease or not. But assuming that the board finds out about it or the management company finds out about it, then the board's responsibilities start to come into play, and they have to make the right decision. Okay, well, that's about all that I have to say preliminarily on this topic. And as I say, I don't profess to have every single answer. We do this on a day-by-day analysis and a day-by-day basis. And it obviously depends on the particular aspects of every community that we represent. So not every community is the same. Obviously, they have different documents. They have different physical structures. So you have to adapt, I should say, to the physical amenities of each community, and hopefully guide the board in the right direction. Okay,
terrific.
That's where I am have turned my phone off, and I'm ready to go.
Terrific. And
we have also,
sure
by the way, we've also, Mark, as you know, the legal beagles have been assisting us a great deal during this problem, and but they are put away in the bedroom now because they tend to bark during these discussions, and so we wanted to keep them away from this so that it would not interfere with the presentation. But they are very active in their analysis of all these issues, particularly as it relates to dogs. They are somewhat concerned about the virus as it relates to dogs. All right.
That's right. I'm sure they're hard at work in the other room there.
Yeah, they're probably asleep right now, but that's okay.
Very good. Okay, thank you very much, Mr. Meisner. And we do have some questions that have already come in here throughout the presentation that we can get to. Again, for our attendees, if you have a question, please submit it by using your the questions section of your control panel, which is in the upper right corner of your screen. And again, just as a quick disclaimer, we're not able to provide specific legal advice or guidance through this format on your individual legal matters that you may be facing, but of course we're available to do so privately under the terms of one of our retainer agreements, so feel free to follow up with us after the webinar. If you're interested in that, we'd be available to help you. Okay, let's take a look here, get my list of questions up. Wow, we got a lot of good.
Could you eliminate, Mark, will you eliminate the four-letter words from any of those questions?
Yeah, don't worry.
Okay.
Let's see. Deborah has a question here regarding, giving a break or a moratorium on collections. What kind of proof of financial hardship should a board require to be submitted?
Well, they would have to, I would think, have to obtain proof that the person lost their job and that they presumably have very little or no other source of income, and that hopefully they've had a good record in the past of paying on a timely basis, and that may be sufficient criteria to make that decision. I think you have to be mindful of the fact that unfortunately some people are going to take advantage of this regardless of their economic situation, and I think that I would not recommend that they tell co-owners, hey, there's a moratorium if you tell us that you got a problem. I think that you allow the co-owners to make that request on their own, and if they're smart, they'll make the request before the assessment is due and say, hey, look, I'm having a problem, as opposed to being put into collection and us having to send a notice of intent or put a lien on, and then they get around to saying, oh, by the way, we lost our job. So hopefully the homeowners will be cognizant of the fact that they've got a problem and they owe the assessment. They should be telling us that now. Now, the question is whether the board wants to advise them of that. But again, I'm somewhat reluctant to, and I may change my mind, but I'm somewhat reluctant to encourage people to do this, if they don't need to do that. And if they do need to do that, then, there's enough public information available for people to know that, credit card companies and mortgage companies and various other entities are giving you a pass for a month or two in terms of, making your payment. In some instances, they're waiving interest and late charges. In other instances, they're not, unless you have a good payment record. I can tell you from personal experience that credit card companies are not going to give you a break unless you have a history of paying everything on time. That gives you a leg up in dealing with the credit card company about getting an extension. That may not be the case in every situation, but again, you've got to be careful here because you don't want to undermine your whole collection policy and then you end up with no money and in deep doo-doo, and at some point in time down the road, the people won't be able to pay, and then then you have to turn everything over to the lawyer to try to collect the money, and it's just a bad situation.
Right. So it's interesting. So your advice to a specific association may differ a bit based on where their collections are at generally right now. If you have a lot of people delinquent, if you're in litigation, you might be less likely to advise an association to allow a moratorium. Is that correct?
Right. And even in the best of times, there are occasions when we recommend to our association clients that they work out a payment plan as long as it's reasonable to try to resolve the thing. Many times, as we find out, because we go over all of our collections every month, once or twice a month, we find that the payment plans that people have honored have not been kept, and then we go ahead and pursue them as aggressively as we can. So everything it's generally on a case by case basis. You have to evaluate a number of issues in deciding how you pursue a collection matter in any given situation. Is there equity in the unit? Is the co-owner working? What's the past history of the co-owner in terms of paying assessments timely? Is the co-owner renting his unit out? I mean, there are a whole number of criteria that we look at, having had this experience for 45 years in assessing what is the best means of handling the collection and whether a break should be given to the co-owner involved.
Okay, terrific. Moving right along, we have another question here from Henry. He asks, what is the authority that requires written authorization by the infected person before disclosing their identity? So I guess, correct me if I'm wrong, Mr. Meisner. So there's not actually any specific statute on this, correct? This would just be more a case of making sure that the association is less likely to be sued as a result. Is that correct?
Yeah, I'm not aware of any specific statute. There are probably some privacy rules. Whether it applies to a community association, I'm not sure. But the fact of the matter is, it's like disclosing that some co-owner is delinquent in his assessments, which you don't want to necessarily do because you have a lot of other remedies. If you happen to disclose that a co-owner is delinquent in his assessments and the co-owner isn't delinquent in his assessments, he can turn around and sue you for libel, for misrepresenting his situation. I think the prudent thing to do is not to disclose the person's name, and unless he authorizes you to do so, and I doubt that he will do that. So I think that to the extent that you indicate that someone is ill, in the situation that I have here in Florida, and it's not necessarily precedent setting, they did give the address of the co-owner. On the other hand, they indicated that the co-owner was no longer at the site and that the people that interacted with the co-owner have been notified. So I just think it's prudent at this point in time. And again, we're in a new situation. We're in a new world here in terms of dealing with issues that we've never had to deal with before. So I think we have to apply past procedures and precedents and ideas on how to deal with disclosure and things of that sort. So I would not disclose the name of the person unless you got permission. If the public if a Department of Health wants to disclose the person, that's their call. If they think it's in the public interest to disclose the name of the person and where he lived, let them do it. That would be my advice to an association. Again, trying to limit the exposure of the association in these difficult times.
Okay, terrific. And we had another question here from Audrey. She asked, when can landscaping resume? So I assume that we would have to pay attention to the governor's executive orders, and when the current order is rescinded or not extended, then after that date,
right,
then things can start getting back to normal, right?
Yeah, but again, for example, here in Florida, which is extremely lax in my opinion, they are allowing landscaping. Of course, Florida is a whole different ballgame. But I wouldn't worry about the landscaping unless you're in the management business and you're getting paid for it. I think that anytime you're exposed, and I'm playing doctor here, anytime you're exposed to anybody under these circumstances, you're running a risk. And even though you may not go outside and look at the landscaper, I don't see things clearing up for a considerable period of time. That's just my uneducated guess. So I can't tell you when landscaping will be permitted. I think it's more of a political decision now than anything, because some states allow it, some states don't. Michigan apparently doesn't. So the grass may grow or the snow may come, and you're just going to have to wait it out.
Okay, very good. And here's an interesting question. So Ann asks, co-owners are walking about the property without a mask. So I guess the question there is, what could the association do about that? Could the association get an emergency bylaw in place, do you think, to require people to wear masks while they're in the common elements?
That's a great idea. I think that would be, it might be a rule. They may not need a bylaw amendment. They might be able to get a rule passed that says, if you're going to traverse, again, it depends on we talking about an apartment building, what are we talking about? And you want to keep 6 feet or more away from anybody anyway. But again, people that are smart, in my judgment, are wearing masks. I mean, it's being encouraged. It works, supposedly. And if the board wants to pass a rule saying if you're going to traverse the common elements, or you're going to go into an elevator, or you're going into the laundry room, assuming you can get a hold of a decent mask, wear it. It's a great idea, actually, and I think the board of directors would have the authority to promulgate that, and it would have a helpful effect on the co-owners anyway. And all it is a codification of policy that's being promulgated by or promoted by the medical practitioners. So that might be something that we would recommend to our community associations, that they promulgate a rule about wearing masks outside, because it just makes sense. Good
Terrific.
question. Yeah.
All right. Thank you, Ann. Let's see. So this is interesting. So there's one person who said, this might be a little bit too specific, so let me know, but it says, we have 4 residents per building. One of the residents has a steady stream of visitors. Can we send a violation letter and prohibit the visitors? Might be legal advice. I'm not sure. What do you think?
Well, I'm not going to. I guess my point here is that the governor has passed a rule, okay, and the governor or the police authorities have the responsibility, theoretically, of enforcing that. Whatever agency is involved in enforcing the governor's proclamation. Presumably, their documents allow for or incorporate by reference laws and statutes of the state of Michigan and things of that sort. So theoretically, they could claim that they have a right to enforce that, but that's again debatable. So I think what they do is they get a legal opinion from their attorney as to how far they can go and what, if anything, they can do under their present set of documents and the governor's pronouncements to see whether they can do anything about that. It may be,
Okay.
hey, they send a friendly reminder to the co-owner that they're obviously jeopardizing the health of themselves as well as their neighbors. And, again, it depends on the physical structure we're talking about. Is this an apartment building where, there are 10 people on the same floor as these people that are going to visit? So I would say clearly in that situation, that's ripe for a legal opinion from their attorney.
Right. Good. Okay. And let's see. We have maybe time for one more question here regarding closing common elements such as a pool. LSAO asks, is there a recommendation until when it should be closed? Could we just state that it would be closed until allowed by the state to be opened again? So I guess so would you state right now when it might be opened again, subject to governor's orders, et cetera?
No, I would. If we're talking about Michigan, I don't think it's 90 degrees yet. Okay, I don't think we have to worry about the pool opening right now, if I'm not mistaken. Down here, it's
That's
been
correct.
89. Yeah, it's been hot as heck down here, and the pools have been closed. But I think that, again, to prognosticate what the future is going to be in terms of how long this thing is going to last and how long these prohibitions are going to be on is purely speculative. And until it gets warm, I wouldn't worry about the pool opening. Because obviously you can't do anything, and if the governor has ordered gyms and pools and things of that sort, which I think is the case, to be closed, you wouldn't even think about doing it until the governor lifts that stay. And even then, after that, the board, I think, as I think ahead here, has to make a business decision as to whether they still think it's appropriate to open the pool, given the fact that the virus is still around. So just because the public authorities, like, for example, here in Florida, they're opening up a beach again. For what reason, I don't know. But the mayor of Marco Island seems to think, well, people are walking outside, they can go to the beach. I mean, everybody's got a different view on how to handle things. In my view, caution should be exercised in every respect in dealing with common areas in a community association. And if somebody's not happy that the pool is open in the summer when there's still an epidemic going on, so be it. Let them try to deal with going after you at that point in time. I think you have a justifiable basis, particularly if you have medical people backing you to continue the policy of keeping the pool closed. But again, that's something that individually has to be considered by each association.
That's a good point, and of course there are competing interests, right? As far as business interests that want to get started again, and governors, presidents, of course, all have that bearing down on their minds. So that's a competing interest against what is the community association's interest in individuals, of course. So that's good to keep in mind.
Right.
Okay. Terrific. Thank you, Mr. Meisner. So we're going to wrap it up, and in closing, we just want to thank you all again for joining us today. And I got several questions about this. We will be emailing everybody who registered a link to the recording of this webinar. And please do feel free to share it with your fellow board members, co-owners, and managers. We'd appreciate that very much. Also, if you were forwarded the email invitation for this webinar, if you found us on social media, we invite you to join our free email newsletter by visiting our website at meisner-law.com, and you can sign up there. Finally, just to let you know what's coming up, we would like to invite you to join us for our full 4-week webinar course over 4 Tuesday evenings in May, and that's our Advanced Community Association Operation course. It would be good for everybody attending here. More information about that can be found on our website, and I'll also ensure that everybody's emailed a link to that for more information after this webinar. So again, thanks again. Be safe, everybody, and have a great afternoon. We appreciate it. Thanks.